Hello, everyone. Today we are with Brett Henry, and we will discuss with the OFAC and the subpoenas and the request for informations in the complex landscape. And my name is Safak Herdem. I'm the managing partner of Herdem Attorneys of Law and leading the international trade practice. Brett, can you introduce yourself shortly?
Sure. Thank you, Safak. And it's nice to be here with you. I appreciate the opportunity. I'm Brad Henry. I'm a partner at Akerman, LLP in New York City. I'm a member of the White Collar Defense and Investigations Group, and I also sit as the co-leader of the sanctions and export control practice at the firm. Our practice focuses on dealing with issues for foreign financial institutions, foreign companies, and foreign individuals related to anti-money laundering, Bank Secrecy Act, foreign corrupt practices, and of course, sanctions and export control. So happy to be with you today.
In this challenging world, it's crazy to deal with the sanctions world and the sanctions business, actually. Brad, I want to ask you some questions about the subpoenas and the request for information of the OFAC. Can you provide an overview of OFAC administrative subpoenas and the RFIs and their significance in the regulatory compliance?
Sure, happy to. So subpoenas and RFIs are similar in that they are requesting information, but different in the way that they do it and the legal authority underpinning them. And so we'll start with RFIs. RFI, a request for information, is really an informal way for OFAC to request information from a company, a bank, a person, and often you will receive those as a letter or some other communication through email saying that, we are requesting certain information from you related to certain topics, and we would like you to respond. The response period typically is 30 days. Compare that to a subpoena. A subpoena, as most of you probably know, is an official document with some legal authority behind it. In the case of OFAC subpoenas, the power to send subpoenas really comes from a few places. One is TWIA, which is the Trading with the Enemies Act, which is a U.S. law, an older one. The other is IEPA, which is the International Emergency Economic Powers Act, which controls essentially sanctions in the U.S. And then thirdly, and the one that you'll typically see on the actual subpoena when you get the document, is from the regulations, from the OFAC regulations, which are at 31 CFR 501. And so there's a whole series of regulations, including the regulation that controls subpoenas. And so Section 602 essentially says that, and I'm quoting here, every person is required to furnish under oath from time to time and at any time as may be required by the director of the Office of Foreign Asset Controls, complete information relative to transactions and other information. And so the subpoena has actual authority. We'll talk a little bit about what the consequences are for not responding to a subpoena and the jurisdictional questions related to can a U.S. government agency serve subpoenas on a foreign person or company, which has been, litigated a bit, but is still a little unclear. So primarily, those are the two differences. A request for information is an informal request. A subpoena is a request with, consequences of law behind it.
So what are the common reasons why a company might receive a subpoena or RFI?
Okay. Well, there's a lot of reasons why a company may receive one of those documents, and from personal experience, there are a lot of reasons. So the first, and obviously the one that you hope that it is not, is if you or your company is under investigation. OFAC, just like the Department of Justice or BIS or other U.S. enforcement or administrative or regulatory agencies, conduct investigations about companies and their conduct on a regular basis. And And so there have been instances in the past where, for example, there is a dual track Department of Justice and OFAC investigation where the Department of Justice is doing its own investigation, but you receive a subpoena and or a request for information from OFAC. And really what they're doing there is trying to gather information about your conduct to determine what their next course of action will be. And so, they can issue a warning letter. They can issue an administrative penalty. And there can also, in some instances, be criminal responsibility. Importantly, when you respond to a subpoena or an RFI, OFAC doesn't necessarily have to keep that information to themselves. They can share it with other regulatory or law enforcement agencies. So keep that in mind if you are thinking about responding. And we'll talk a little bit more about that later. Another reason they might send one of these requests for information is because they are investigating others, right? They may be interested in the conduct of someone who is banking at your bank, if you're a financial institution, for example. They may be, if you're in the import-export business or dealing with ports and shipping, they may be interested in what a particular boat or ship is doing and trying to find out what is going on with shipments and where they're going and when. So that really, they're trying to gather information about some other person doing something. Those are the primary reasons that they would send these requests to you. And it's important, I think it's important to note that, before you get these requests, you should have a good understanding of what your business is doing and who you're dealing with. So when the time comes, you understand. But if you're caught out and don't, you don't know what's going on, of course, you should look into it before ever responding.
Yeah, in this regard, I want to ask you about the industries, the sectors. Are there specific industries or the sectors that are more likely to be targeted by the OFAC administration and targeted by the subpoenas or the RFIs? And if so, why?
Yeah, yes. And I think historically this has been true, right? OFAC is not infinitely resourced, meaning that they can't chase down every thread to figure out what's going on. And so they have to target the areas where they want to focus and the companies that they want to focus on for maximum impact. And so you will see historically the public settlements with OFAC have typically, been related to banks and financial institutions, obviously, manufacturing, the manufacturing sector, oil and gas. They focused on technology and some other areas that relate to those types of industries that really, move governments and move populations. And so when they're thinking about like what industries do we want to focus on, those are the ones most typically. I think it's important to note while we're talking right now, most of you will be aware, but if you're not, it just a couple of weeks ago on December 22nd, the Department of Treasury, OFAC, put out a directive saying that they would directly sanction foreign banks found to be facilitating certain transactions for Russian entities or individuals. I think, based on that and based on a little bit of what's been going on in terms of the public releases from OFAC, I think you can probably expect that OFAC is going to be focusing again on banks and banking transactions that assist in the Russian aggression in Ukraine. And so that's one area that they are particularly focused on right now. And then, of course, all of the industries related to and surrounding Russia and their economy are going to be places where OFAC is focused. The other place where OFAC is going to be focused, I think, more and more in the future is in the technology sector as it relates to China. And so I expect, to the extent that there have already been sanctions, there will be more activity there as well. So we should keep an eye out for that.
Yeah. So what steps should the company take immediately upon receiving such a subpoena and RFI? What are your suggestions?
So imagine you're a company and you receive an email that has an RFI or a subpoena. What do you do? What are the first steps? Well, step number one, obviously, is to call your legal department. If you're not in the legal department, if, for example, you're an executive and you don't, and you're not a part of the legal department, you'll want to involve your legal department at your company immediately. If you are a member of the legal department, it is very likely that you will want to contact your external counsel and forward a copy of the RFI to them immediately. The more time you have to react and respond, the better off you are. If there are any questions, once you get the subpoena, you review it, you think you understand what it's asking for, but you'll always want to clarify. And oftentimes you'll want to try to reduce or modify the scope of the subpoena, because in many cases they ask for a lot of stuff, and it's not really either realistic or practical to go and chase all that information down. So contacting OFAC or having you don't want to contact them, having your counsel contact OFAC to ask questions about the subpoena, to get an understanding of what is the reasoning behind receiving the subpoena. What do we need to do in terms of responding to the subpoena? Can we limit the scope of the subpoena? Can we answer some questions and not answer other questions? Can we do it on a rolling basis, meaning we don't give you all the information at once, and then have discussions about the real purpose behind the subpoena to see if you can meet their expectation without providing every single document or every single thing. The other thing you'll want to do is probably ask for more time to respond. They're usually very relaxed about the response times. They want an answer, but they understand that sometimes it takes a little bit of work to get an answer. So there's the things that you can do in terms of OFAC facing activity. What you'll want to do internally, of course, is understand what the issue is. If there is not a body of knowledge related to that particular transaction or activity, you would want to consider looking into it further. You would go through the step. This is a separate discussion, but in terms of an internal investigation to understand what happened, when it happened, who was involved, what the issues are, and where your company potentially faces liability, if any, and how to mitigate that will be very important, and you'll want to do that very quickly. And so it's sort of a two-step, right, where you're contacting OFAC to get additional time and understand what they want. Internally, you're looking to see what actually happened, to see where your risk is, and to then begin strategizing about how and if you will respond to the subpoena, and with what information, and what kind of argument you will want to make internally. And your external counsel will help you with this. Is for instance, if you're a financial institution and under this new regulation in the U.S., you receive a subpoena asking about transactions related to Russia. You'll want to understand that in great detail, because one of the things you're going to want to do is in that response, when you send it, if you can send it, and we'll talk about that in a second, in that response, you will want to advocate to the extent possible on behalf of yourself, so that you are, at the same time you're responding, you are educating and advocating to OFAC that you were in the right, that you as the financial institution didn't do anything wrong, or that you have measures in place to mitigate any wrongdoing, and therefore they shouldn't be focused on you. They can take their focus somewhere else. Particularly, of course, with Turkish clients, and doing lots of work in Turkey and dealing with these issues, Safak, you'll know that there are many Turkish laws, local laws, that you have to contend with, right? Privacy laws, regulations from Masa and others who, when you're responding, they may ask for account information for individuals. Well, does Turkish law prevent you from doing that? Are there privacy directives that would prevent you from being able to respond? And how do you deal with that with OFAC? And how do you navigate that internally with the local law when it collides with the request from U.S. authorities under U.S. law, which in many cases are very different. And so you'll want to understand the nuances of what you can respond to is another issue. And so anticipating all of those things in advance, you can, as a company, come up with steps and procedures and processes that you'll want to put into place ahead of time, so that if you receive a request, either informally or formally through a subpoena, what action you're going to take, so that you put that into process. And then you can respond, because as we all know, if you don't respond, there are obviously many potential consequences.
So in this regard, I want to ask a question about the legal assistance, and what factors should the company consider when deciding whether to seek a legal counsel for a subpoena or RFI?
Well, so I think the question, just to cut to the chase, if you receive an RFI or a subpoena from OFAC, you should get external counsel, period. And I think there are levels of what happens surrounding that. In a situation where a company becomes aware of a potential violation or issue that they are concerned about and they want to look further into, right? There is a level of measuring whether outside counsel is needed or not, and you base that on what's the experience of your internal counsel with doing those types of internal reviews or investigations. What is the bandwidth to be able to do that? Will you be able to preserve privilege if you do it internally, and how does that affect the outcome and reporting of that activity? And then finally, what is the severity of the potential issue, right? What is the potential penalty and outcome of that? In some instances, you may be able to get away with doing an internal review, but in most instances, for something that is of any serious nature at all, you're going to really want to consider external counsel. Taking that a step further, if you receive an RFI or a subpoena, right, you've already gone into that world of being in a very serious position, right? Because even if you are not the target of the investigation with OFAC, the information that they get, they're going to look at. And if they find issues with you that you either didn't anticipate or you weren't prepared for, then that could lead to unwanted consequences, like an investigation then turning its focus onto you, which you obviously do not want. And so my recommendation, in any circumstance where you receive communication from an outside regulatory agency or an enforcement agency, you should be going to external counsel immediately to be able to look into the issue, to understand the potential consequences, and importantly, to preserve your attorney-client privilege and make sure that everything is insulated in terms of what you're looking at, so that when you provide the information, you're providing what you want in the way that you want, but not, providing those things that would otherwise be privileged if you had external counsel involved.
I understood. I want to turn to the responses. What are the key elements of an effective response to a subpoena or an RFI?
Yeah. So obviously, the most key factor in responding to any request from a governmental authority is to be truthful, and forthcoming in terms of the information that you provide. There are serious consequences for lying, and in some instances omitting information that is relevant to the review. I'll give you two examples. There are cases supporting both of these. In one instance, a company received a subpoena and affirmatively misled the government in the way that they responded to those requests for information, and ultimately the government found that they had made affirmative misrepresentations, and in addition to the consequences of the actions that were taken under criminal law for sanctions violations, they were also charged with what's called a 1001 violation. Under U.S. law, a 1001 violation is a criminal charge that results from lying to the government, essentially. And so even if you were to go to trial and be successful in defending against the sanctions issue or the money laundering issue or whatever comes up, you would still be separately responsible potentially for lying to the government. And so that's just one more thing that they can put on top of, potential charges that you don't want. So obviously, first thing's to be truthful. Another instance is in terms of omitting information. There was a company that information was requested from related to Iran sanctions a number of years ago. They provided fully all of the information truthfully up to a point in time, and all of that information was fine. There was no issue, but the government ultimately discovered that there were communications after that period of time where the deal that they were doing closed and wrapped up, and it became clear that they were communicating about sending a certain product to Iran. And so not only did the government discover that, but then they were ultimately penalized for omitting that information, both in terms of the credit that they got and their ultimate settlement, but then also they could have faced additional charges, criminal charges for omitting that information and purposefully. So, first you have to be truthful, and you have to give the information that's requested. The second thing, obviously, that's important to do is to make sure you're not that you're complying with the subpoena in terms of what it is asking for. Not always in subpoenas do you want to give them more than they're asking for, right? You want to answer the question, give them the documents or the information, and then be done with it. There are instances where there are strategic reasons why you would give the government more than they were asking for, right? If it's to your benefit. And then, and so, figuring out what it is that you're providing and how you're providing it. And then I would say the third important factor is what I talked about earlier, is making sure that when you respond, you are doing it in a way that is compliant with the law that you have to follow as part of your jurisdiction. So if you're in Turkey, for example, or you're in Brazil, or you're in France, you'll want to take a close look at the local laws there to make sure that you are compliant with those obligations before you send information to a government agency in the U.S.
Brett, is there any in the OFAC regulations in responding to subpoenas or the RFIs?
If you fail to respond?
Yeah.
Yeah. So yes, so for an RFI, if you fail to respond, a few things can happen. Number one, they could issue a subpoena, right? There is no sort of legal mechanism to respond to a failure to answer a request for information, because it is informal. It's just a request. That's all it is. And so you can ultimately you can decide whether you want to respond to that or not. If you don't, the potential consequences are these. One is OFAC may have already enough information to come after you. So you may have lost an opportunity to have a discussion with OFAC and convince them that you are compliant, and or the issue that they're looking into is not as serious as they believe it to be, and the opportunity to negotiate with them an outcome that is less serious than what may ultimately end up happening if you just simply fail to respond, right? They will assume the worst. The second thing that could happen is if they are investigating you, or you are unresponsive, they always have the option unilaterally to sanction, right? And so they can add you to a sanctions list, which then would cause your company significant financial and economic hardship. And so a failure to reply could result in that. The third potential outcome is that they would just issue a subpoena, right, and make you deal with the official request at that time. If you do get a subpoena and you fail to respond, then the government has the option to take that to court to try to enforce it. The other same consequences for failing to respond to a subpoena exist, right? Which is being sanctioned and or them, assuming the worst and just moving forward with an enforcement action without your response. And then ultimately, if they want to take you to court to get a response to a subpoena, if they don't have enough information either to charge criminally or to sanction, but they really need the information to move forward with whatever investigation they've got going on, then they would take that to court potentially, and you could too, if you feel like you've gotten a subpoena that is unwarranted or overly broad, or should be quashed because of legal infirmity or failure to properly serve it. You potentially, through your counsel, come to a U.S. court and challenge the subpoena. There has been litigation over those issues, right? And so there is a legitimate question about whether, for example, there is a uniquely Turkish company, right? It exists only in Turkey, but does not exist or have any operations in the U.S., right? Can the government of the U.S., can OFAC send you a subpoena and expect to be able to enforce that? That question has gone both ways, and it's really sort of factually dependent in terms of what kind of presence the company has in the U.S., what sort of activities do they have going on in the U.S., what are the touch points there. Correspondingly, if, for example, you're a financial institution, you're a bank, and you have operations overseas, but you have a branch in the U.S., or you're a company and most of your operations are overseas, but you have an office in the U.S., right? What OFAC will often do is they will then issue that subpoena to your U.S. office or branch and say, we want a response to our subpoena, but we want information not only that you are in possession of, but also all of your overseas operations are in possession of. Now, courts have typically found that that's appropriate, that presence in the U.S. and serving that entity located in the U.S. then gives authority for them to reach out to the overseas operations to get information there. And so that's one of the issues in a way that OFAC will sometimes handle that. Does OFAC have that authority in every instance? Of course, it will depend on the facts and circumstances related to your activities and connections to the U.S. or otherwise. So, in most instances, it is the right course of action to respond to a subpoena in some way, even if it is to challenge the subpoena. Leaving a subpoena request for information totally unanswered is often not the course of action you want to take. The government will assume the worst, and so you'll want to take some steps to provide a response, even if it is we don't intend to provide a response for these reasons.
So about the strategies and the considerations, are there any strategies or considerations that can help streamline the response process and minimize the impact on day-to-day operations during an OFAC investigation?
Yeah, absolutely. There's there is a lot of strategy that goes into this, and it will really be dependent on the company, and it will be affected by the size of the company, what operations are going on, what business unit potentially was involved. Was it a limited group of people who potentially were responsible for the alleged violation, or is it a larger group or team within the company? Who knows at this point? How did you become aware of the information? Was it through a whistleblower? Was it because you received an RFI or subpoena? Is that the first time you've ever heard of it? How widely known is it at that time? Other considerations: are you publicly traded, right? Do you have responsibilities to report investigations or other things that are happening, and what are those obligations and the timing for those? So in terms of strategies, though, if you find yourself in a situation where you've received an RFI or subpoena and that OFAC is investigating either you or a third party, you want to take a number of steps in conjunction with your legal counsel and your external legal counsel, which include, memorializing the group at your company who will be responsible for the investigation. You'll want to try to keep that information as controlled as possible. And we all know that rumors and untrue information is harmful to an investigation. To the extent that you have to collect documents or other information, you will want to do it sort of as quietly as possible, so not to raise alarm unnecessarily. And then you'll want to begin making decisions about that information, what occurred, and how to communicate that to OFAC very quickly. I think it is important to me in almost every instance to reach out to OFAC as quickly as possible to say that we are on this, we are looking into it, and we will respond to you within a period of time. That will give OFAC some comfort that it is being handled and that you have competent counsel who is helping you navigate the request. It will give them some comfort that they don't need to take some immediate action that is unwarranted at the time. It will engender the ability to have communications back and forth with one another that are productive and not as confrontational as they may otherwise be. And it's important to keep in mind, right, that OFAC is not an organization meant to penalize, right? It is not a punitive administrative body. They are ultimately responsible for attempting to change behavior. If they see some behavior that is happening that is something that it potentially violates sanctions, they want you to change that behavior, right? They don't necessarily want to punish you, although often it happens as a consequence of their conduct. And so getting ahead of that, not every situation where a violation has occurred results in some sort of sanctioning action, right? More often than not, in this day and age, you will get a warning letter, or you will get some other administrative penalty that does not result in a huge monetary fine or being added to a sanctions list, and certainly not criminal responsibility for those kinds of things. But that all requires a level of communication and interaction with OFAC that starts as early as possible. And so I think in terms of strategy, it's get the information quickly, communicate quickly, and then make decisions that are appropriate for your company so that you can deal with the issue as cleanly and as quickly as possible.
Mm-hmm. This is my last question before moving to the questions from the audience. That what are some proactive measures that companies can take to minimize the risk of receiving a subpoena or RFI?
Sure. This is actually a really great question, because it goes to a point that I think is very important, which is companies should really be thinking about, if they haven't already, and if they do, they should be using their proactive compliance to make sure that they are ahead of these issues. So, for example, I've represented dozens and dozens of companies who have had to interact in one way or another with OFAC and the Department of Justice National Security Division in relation to investigations for sanctions violations of all kinds. And the one thing that I will say is that the more proactive you are ahead of time, typically the better off you are in the end. And so to the extent that you, as a company, are monitoring sanctions, potential sanctions violations, screening companies, doing beneficial owner, know your customer protocols on intake, screening the sanctions lists, and having those procedures and policies in place that help you understand if there's a potential violation before you ever receive a subpoena or RFI, the better off you are. There are some instances, right, where it is better to report conduct ahead of time. And there is a fair amount of strategy involved about self-reporting and voluntarily self-reporting that you'll want to go through in each instance. But OFAC does have written guidance related to the credit that you would get or the benefit that you would get of reporting conduct ahead of time, right? And that's important to know that, companies, particularly foreign companies, in all areas of the world outside, really the U.S., are very reluctant to sort of get ahead of things and sort of tell on themselves about something that they potentially have done. But in the U.S., that is not viewed unfavorably. It is actually viewed very favorably in terms of outcome. And so there are very defined benefits that you can get for that, right? No criminal penalty, no monetary penalty. You can get non-prosecution DPA treatment, and OFAC has written guidance on that, just like the Department of Justice, just like BIS at Commerce. And so you'll want to understand that information and take advantage of it when the time comes. And so the best way to avoid or minimize the risk of receiving an administrative subpoena or RFI from OFAC is to just be ahead of them, right? Is to understand what you're doing, where you're doing it, who you're doing it with, and what risk you face, and then take that and turn it towards them to get ahead of the game. Alternatively, if it's important to note that sometimes requests will come before you ever get an RFI or administrative subpoena. And so I'll give you an example that we worked on not too long ago, where a company received an unofficial outreach from one state, from the U.S. Embassy to that company's country embassy. And it was a very informal sort of meeting. They came and said, hey, you have this company in your country who is doing this. We'd like to let you to let them know what they're doing and what we think they might do about it. And so that was a sort of informal reach out. And we were able to then come in, re-engage in those conversations one-to-one, and resolve that issue with no action being taken, and really very minimal information passing back and forth. It was, I'll describe it as more of a misunderstanding than anything else, based on public records, and so we were able to clear that up. But taking those proactive measures, when you start to get information in that something might be happening, you may get hints or clues about it. You should not ignore those. I mean, you take action on that information and try to go out and do something about it.
Thank you for this very insightful conversation and your answers, Brett. We have some questions from the participants. That one question comes from Georgia, actually. It's a general question about the sanctions and how the sanctions affect the U.S. economy.
Well, I guess, first of all, thanks for your question. Secondarily, the U.S., I won't talk about politics. I'm apolitical, but the idea that the U.S. imposes sanctions on foreign countries is well known now. 10 years ago, this wasn't a tool. It was around, it was available, but it was different. Now, as a part of U.S. diplomacy and really national security, sanctions are used more and more. We see that as a result of the war in Russia, or the war in Ukraine with Russia. We see it, the embargoes on Cuba and Iran and North Korea. And then we see it in other places where the sanctions are changing. It's not sort of the sledgehammer anymore. They're a little more surgical, menu-based sanctions and sectoral sanctions, and really trying to add people to the sanctions list to try to cut off their ability to engage in the economy. And so those have a tremendous impact on those countries outside the U.S. And we can debate the pros and cons of those, and the people who suffer as a result of that, who arguably did nothing wrong, but nonetheless, that's the reality that we live in. In terms of the U.S., how does that affect us? I mean, I think it doesn't directly affect our economy. I mean, I would say, for example, if you're talking about if Russia sanctions the U.S., what effect does that have on the U.S. economy? I would venture to guess it's minimal. In our outward facing sanctions in the U.S., what impact does that have on the U.S. economy? And I would also argue that is probably minimal, and many who are in the administration and others similarly situated would argue that the net benefit to the U.S. far outweighs any negative, potential impact that it could have. But obviously, reasonable minds disagree, and there are differing opinions around the world, and it's not a perfect system. nothing
Yeah,
else.
yeah, I fully agree with you. Another question is about the healthcare services for Iranian and the Russian people, and the question is that if these services are also falling under the OFAC restrictions, and is there any sanction-related matter that is related with the healthcare services?
That's a great question, and let me caveat this by saying that nothing I should have said this earlier, but nothing I've said here today is legal advice, right? I can't provide you legal advice
Sure.
unless we have all the factual information and are able to provide you an official opinion. But generally speaking, humanitarian aid is authorized under most sanctions regimes, particularly the Iran sanctions. There's a humanitarian aid provision there, but it is somewhat limited. It is not as wide open as you would think it might be. And so, for example, if you're a healthcare company and a Russian citizen is in your jurisdiction and has an automobile accident, they're seriously injured, and you providing that service to them while they're in country, is that a sanctions violation? I'd have to review, but assume that it was, right? Assume that technically was providing a service to someone who was sanctioned, for example. Would your health care institution, be in trouble for that? I think OFAC and other U.S. regulatory agencies and enforcement agencies get a bad rap as being particularly harsh. And I don't know that I disagree with that. They are sometimes harsh and sometimes purposefully so. But are they going to take time out to come and do something to you about that? I think they also have, good sense, and they are able to discern between those kinds of actions that require some input from them versus those that are, common sense tells you that they're not going to take some action. And so I think that the answer to your question in that instance is a complicated one, and depends on a number of factors as it relates to who the person is. Are they on a sanctions list or not? How are they in your country? Under what law do they fall in terms of their tourist status and visa status? So I can't give you a really good answer without many more facts, but I would venture to guess that that it is important not only for OFAC and others that people get health care when they really need it. That's something that you should rank on your level of risk appropriately.
Yeah. Thanks, Brett. There is another question. I know that we really dislike to speak about the politics and some specific issues and the cases, but the question is that that the Turkish banks are about to be sanctioned, like Halkbank, by holding assets owned by the Hamas, considered a terrorist organization by the U.S. What's your estimation of another Halkbank case?
If you're asking if there will be another prosecution like Halkbank, the answer is I have no idea. I think the world becomes more complicated every day now with all of the military action that's happening around the world and all of the sort of corresponding. U.S. has sanctions, but so does the UK and the EU and the UN and now Australia and Japan. Russia is sanctioning. So it is a complicated map that you have to navigate with these things. So do I think there will be another prosecution against a foreign bank? It's totally possible that happens. Where in the world that bank might be, I don't know. I think, you see it now, Wells Fargo, Deutsche Bank, Danske Bank, BNP Paribas, all of those banks, right, have faced those serious issues and continue to face them, right? You see, I think just a few days ago, they announced another settlement with a payment services company where, payments are running through related to this stuff. And OFAC takes action. So it's totally possible that there is, there are prosecutions coming. I think more likely than not, though, not related to Hamas, although that may be a little further down the road. But I think there are probably some very significant actions coming related to Russia sanctions pretty soon. We've been hearing it for months on end that there'll be enforcement actions, there'll be stuff that's happening, there will be issues, and just a week or so ago, they said that there are going to be a number of cases coming down very soon related to Russian sanctions. Now, as we all know, most of these OFAC actions end in a settlement of some kind, right? So behind the scenes for months or years on end, they've been negotiating this, and we don't hear about it until the very end, which is a little bit different, I think, than the scenario you're talking about, which is an actual, somebody getting arrested, and crossing the port. Or a real, prosecution in court with trial. Those are more rare, but that's, that's a sort of a function of how, I guess, the negotiation goes on the back end. But I guess that's the best I can answer that, is maybe we'll see something like that again.
Yeah. No one knows about it.
Nobody knows.
Yeah. And the last question is, can you discuss a recent case of a preferable Turkish company or a company from where the others can learn something from the mistakes?
Yeah, well, I mean, there's a lot of cases, and you can actually go if you're looking particularly at OFAC. OFAC publishes all of their, administrative actions on their website, so you can go and look at those, and they try to give a description of what occurred, such that other companies can try to learn from that conduct. And it's a pretty useful resource. Unfortunately, there is not. I keep advocating for this. So if anybody's smart at technology out there, it's a good opportunity. But to sort of bring in all of the OFAC decisions and all of the DPAs and non-prosecution agreements and declinations that have occurred over time. There aren't really that many of them, right? I mean, you in OFAC action over the last several years of reported settlements are probably less than 100. Many of them early on being the big bank settlements, and then more recently sort of diversifying industry and size of the type of settlements that they're making. So you certainly can learn from those. I think OFAC, if you go back and look at what they're particularly focused on, there are a class of, or a category of sort of transactions that they are typically looking at. You will see that many of them follow a little bit of the same pattern. Turkish companies in particular, though, there have been a number of designations of Turkish entities or individuals over the course of the last several months under the Russia sanctions in relation to, component parts for missiles, for oil and gas issues, and those kinds of things. So those are sort of out. I would say those are a little bit of outlier cases in terms of just being added to the sanctions list. But if you're really interested in learning about what it is that your company is doing and may not want to be doing, I would advise you to seek counsel who deals with this issue often. They can give you a very good rundown. And oftentimes we do it, pretty regularly, is we'll come in and do trainings and talk about those, sort of tailored to what your company is. I'm sure Safak does this as well, where you come in and you have these trainings and you look at the company and you identify where their risk might be, and then you try to help them mitigate that risk and avoid future issues.
Yeah. Thank you, Brett. It was a great conversation, and it was, as always, it's very insightful. And I hope that all the people who listened to us today and will be listening on the Spotify and YouTube channels will be getting some benefit of this fruitful conversation. Thank you for everyone.
Thank you
Maybe
all
the last was. Thank you.
very
Thank you.
much. Take care.